Hello everyone, myself Vaibhav Verma and I am a part of LEXIS and Company as a legal intern. Today I am going to talk about on a topic of remedies for breach of contract under Indian Contract Act. As we know that contract is an agreement which is enforceable by law. In other words, a contract is an agreement between two parties or more to create an obligation. So when an agreement enables a person to compel another to do something or abstain from doing something is called a contract. Now let's see what is breach of contract. A breach of contract can be said to as when either of the parties fails or refuses to perform his obligation or his promise under the contract. Therefore, it can be said that when a binding agreement is not honored by one or more parties by non-performance of his promise, the agreement can be said to be breached. For example, A and B enter into a contract and where A promises to buy B's car on for rupees 1 lakh and B agrees to that. If A fails to pay rupees 1 lakh there is a breach of duty by the party A. So this is a breach of contract. As one party commits a breach of the contract, the law grants to the other party three remedies. He may seek to obtain damages for the loss sustained, a decree for specific performance, an injunction. Let's with the given example, if A fails to pay the rupees or refuses to pay rupees 1 lakh, here B can sue him as B can sell his car to anyone for more than rupees 1 lakh. B can sue A for the damages he has sustained. Now let's see the remedies one by one. Number 1 remedy is damages for the loss sustained. Section 73 of the Indian Contract Act 1872 lays down 4 important rules governing the measures of damages. First rule given under section 73 subclause 1, which is when a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damages caused to him which naturally arose in the usual course of things. Such breach or which the party knew when they made the contract is too likely to be result from the breach of contract. Second rule is given under section 73 subclause 3. Second rule of measuring damages deals with the remoteness of damages. It states such compensation is not to be given for any remote and indirect loss or damage sustained by the reason of the breach. Damages are measured by the loss actually suffered by the party. The loss must naturally arise in the usual course of things from the breach, or it must be such as the party knew when they made the contract to be likely to be the result from breach of it. Third rule is an explanation given under section 73, which provides that in estimating the loss or damages arising from a breach of contract, the means which existed of remedying the inconvenience caused by the non-performance of contract must be taken into account. Fourth rule is section 73, where it is noted that damages payable for the breach of quasi contracts are exactly the same as those payable for any other contract. To rephrase, all the above rules apply to the quasi contract in the same manner. It should be in the note that when no loss arises from the breach of contract, only nominal damages are awarded. Damages are given by way of restitution and compensation only, and not by way of punishment. The aggrieved party can therefore recover the actual loss caused to him as compensation. Now let's understand this topic with an example. For example, a contract to repair B's house in a certain way and receive the money in advance. A repairs house but not according to the contract. B is entitled to recover the cost of making the repairs conform to the contract from A. Now let's see what are the types of damages under section 73 of the Indian Contract Act 1872. Number 1 damages is nominal damages. In this, if the defendant is found liable for the breach of contract, the plaintiff is entitled to nominal damages even if no actual damage is proven. Nominal damages are awarded if there is an infringement of a legal right and if it does not give rise to any real damages. Next damages is substantial damage. In this case, where offence is proven, many authorities may claim substantial damages even if it is not only difficult but also impossible to calculate the damages with certainty or accuracy. Where a defendant refuses to accept goods sold or manufactured for him, the plaintiff sells them to third party on the same term as the defendant agreed and makes a similar profit. The plaintiff shall be entitled to nominal damages if the demand exceeds the supply of similar goods. But if supply exceeds the demand, the plaintiff shall be entitled to recover his loss of profit on the defendant's contract. Next is liquidated and unliquidated damages. Unliquidated damages. Liquidated damages are one which are fixed by the parties. It is a sum agreed by the parties of the contract as payable on the default of one of them. So liquidated damages are those damages which can be calculated in actual figures or in accurate way, but unliquidated damages are those damages which cannot be calculated or it cannot be measured. Another one is consequential damages and incidental loss. Consequential damages or loss refers to pecuniary loss resulting from physical damage, that is in the term of monetary, whereas incidental loss refers to the loss incurred by the complainant after he became aware of the breach and made to avoid the loss, that is cost of buying or hitting a replacement or returning defective good. I hope you like the video. Thank you.